Hello everyone, this is video number 4 and in this video we will be doing the questions of Indian Evidence Act. Question number 1. Which kind of agreement can be presumed by court under section 85A of Indian Evidence Act? So section 85A of the Indian Evidence Act relates with electronic agreement. This is the correct answer. Question number 2. Which one document from the following is not a public document? So I think in these options, the judgment of the court is the only document which can be called as public document. Otherwise, police charge sheet is also not a public document. Postmortem report is not a public document. Will is not a public document unless it is uh, certified as probate by a competent court. But the question is which one of the document from the following is not a public document? So I think question is incorrect, but the answer is which of the question should have been which of the following is a public document? That would be judgment of the court. Question 3. A witness unable to speak if gives his statement in writing before the court, then such evidence shall be deemed to be that is oral evidence. Section 119 says so. And it is to be noted that section 119 was inserted by, not inserted, it was substituted by 2013 amendment. Earlier it was written as dumb witness. Question number 4. In a criminal case, the primary burden to prove of fact is upon. The answer is prosecution. Prosecution have to prove a case beyond reasonable doubt. And it is said that weakness of the defense does not matter, and prosecution's case has to stand and fall on its own legs. Question number 5. A sues B for negligence in providing him with a carriage for hire not reasonably fit for use, whereby A was injured. The fact that B was habitually negligent about the carriages which he let to hire is irrelevant, because section 14 का जो explanation है which says that अगर जो if anything let's see in explanation. हाँ, explanation 1 to section 14 provides that a relevant fact showing the existence of relevant state of mind. So if it is a state of mind, it must show that the state of mind exists not generally but in reference to a particular matter in question. So it is not relevant कि वो बाकी time भी he was negligent while giving the carriages for a hire. Next question. Question number 6. Under which of the provision of Indian Evidence Act an accused may plead alibi? So section 11 is alibi, which says that facts which are otherwise irrelevant becomes relevant if they are inconsistent with the facts in issue or relevant fact, or which renders fact in issue or relevant fact is so improbable or probable is yes, you can read from explanation. And it is the alibi is not a general exception, but it is a rule of evidence. Question number 7. The doctrine of estoppel means not to make statement in consonance to the earlier statement, restrictions to make statement contrary to earlier statement. So this is the effect of estoppel. It is given in 115 of Evidence Act. Question number 8. An accused in a police custody informs to the state House station, it should be station house officer, SHO. SHO, that the key by which he opened the safe and committed theft by him in the patio of the house. To what extent this information can be proved? So this question is based on section 27, and section 27 says that the information which distinctly relates to the facts discovered, that is, in such cases it should be uh, it cannot be for committing offense of theft. It cannot be for opening lock of safe. It cannot be for committing it. It it can be only for the purpose of keeping the key at the patio of the house. Question number 9. In a trial, while explaining any circumstances appearing in evidence against him, an accused an accused committing murder states that due to grave and sudden provocation, he was deprived of the power of self-control and thus gave a single lathi blow to A, causing his death. The burden of proof to grave and sudden provocation is on. So it must be on accused. It cannot be on anybody else, because he by proving grave and sudden provocation, he would be reducing the amount of sentence which you would get otherwise. So to get reduction in sentence, he has to prove the fact on which reduction of sentence is dependent on. Question number 10. In the Indian Evidence Act, the expression court means all of the above would be the correct option. Question number 11. When court has to form an opinion as to the electronic signature of any person, the opinion of certifying authority which has issued the electronic signature certificate is cannot be a fact in issue, can be it should be a relevant fact. It cannot be proved fact. So the option B is the correct option. Question number 12. During the course of trial of rape case, a person present in the court causes a knife injury to another person before the court. The judge before whom the incident took place may not be called in evidence. Option A. Option B may be called in evidence only under special order of higher court. No. C may be examined as witness. So option C would be the correct option, because this question is based on a privilege, and whenever anything happens in presence of a judge or a magistrate, he can be examined to the fact that what happened before him, but he cannot be examined as his conduct as a judge or magistrate. This is given in section 121. Next question. Under section 32 of Indian Evidence Act, statement of a person who is dead is relevant. Option A, if it relates to cause of someone else's death, no. Option B, if it relates to cause of his own death or someone else's death, no, it cannot be so. If it relates to cause of his own death, section 32 clause 1 specifically provides so. Next question, facts which though not an issue are so connected with the fact in issue as to form part of the same transaction, whether they occurred at the same time and place or at a different time and place. So this is complete wording of section 6 of Indian Evidence Act. So these are relevant. All these facts are relevant fact. It is also called doctrine of res gestae. It means it is so connected with the fact in issue or relevant fact that it cannot be separated. So it is part of the same transaction and hence it is relevant. Question 15. Which of the following statement as per provisions of the Indian Evidence Act is not correct? So facts which are in option A, fact which are inconsistent with any fact in issue shall not be relevant. So this is of course incorrect proposition, because whatever is inconsistent with the fact in issue is relevant under section 11. 11. B, facts. Rest will be, of course, correct, but let's see once. Option B, facts not otherwise relevant are relevant if they, by themselves or in connection with other facts, they make existence or non-existence of any fact in issue and highly probable or improbable. This is also section 11. Option C, any fact is relevant which shows or constitutes a motive or preparation for any fact in issue is a relevant fact. This is also correct. Admission are not conclusive proof of the matters admitted, but they may operate as estoppel under the provision of Indian Evidence Act. I think this is given in section 31. Kindly you may check, please. Question number 16. Which of the following is correct statement according to the law? Option A. An accomplice shall be competent witness against an accused. So this is the correct statement. Section 133 provides that an accused can be a competent witness and conviction based on his evidence would not be incorrect. Option B, leading question may be asked in cross examination. Yes, it can be asked. Option C, the court may permit a party who calls as a witness to put any question to him which might be put in cross examination. So this is section 154 of Indian Evidence Act. Hmm. It means all of the options are correct. Question number 17. Burden of proof under section 101 of Indian Evidence Act. Option A goes on shifting as the trial proceeds. No. Uh, this happens in case of section 102. It is called onus of proof. B never shifts. Yes. So like it is the burden of proof is on prosecution to prove a case beyond reasonable doubt to get the accused convicted, so it never gets shift, or anybody wants judgment in his favor and he has to prove that particular fact, and it cannot be so that once he prove, unless he is supported by presumption, like in section 118 and 139 of Negotiable Instrument Act. So, except in case of presumption, otherwise, the burden of proof is always on the person who wants judgments in his favor. Question number 18. During the course of trial of a murder case, which of the following may be proved? Statement of option A, a statement of confession of accused made in police custody during investigation. B, recovery of the weapon of offense on the basis of statement made by the accused during the investigation of another case. This would be relevant. तो फ्रेंड्स इन दिस केस जो ऑफिशियल आंसर की थी उसमें ऑप्शन वाज D. None of the above was correct option, but as per my research and judgment of the Supreme Court, option B should be the correct option. So it is not correct option. Recovery of the weapon on the basis of the statement made by accused during the investigation of another case is also relevant. There is a judgment on this point. That State of Rajasthan versus Bhoop Singh. In this case, the recovery of pistol was from the statement of accused recorded in different FIR. So, on that basis, Rajasthan High Court set aside the conviction because it was recorded on the statement on other case. But Supreme Court overturned this judgment and held that since the conditions which were necessary for the for the lifting of the ban under Section 27 has been satisfied, then there is no point that such information can be irrelevant. So Supreme Court held that it is immaterial whether the information was supplied in connection with the same crime or different crime. Here, the fact discovered by the police is not the pistol, but that the accused has buried the said pistol and he knew where it was buried. So it is clear that the statement recorded in another case can be relevant for the purpose of Section 27. Next. Question number 19. Which of the following statement is not correct? Option A, the non-examination of doctors endorsing the dying declaration does not always affect the evidentiary value of the dying declaration. So, the word used does not always affect. So it means it cannot be a straight away incorrect statement. So this is correct. Let's see other statements. B, non-signing of the dying declaration by by literate declarant unable to sign does not render the veracity of dying declaration doubtful. So in this case, the declarant is unable to sign. Hence, it is the correct statement, because when he is unable to sign, how can he sign the dying declaration? Option C, when the relatives of the declarants are present during the dying declaration would not be relevant. So this is incorrect statement, because recently, although there are many cases, recently in Satpal versus State of Haryana, it has been reiterated by the Supreme Court that mere presence of relatives does not render a dying declaration irrelevant. Option D, the statement recorded by FIR may be treated as dying declaration. This is also a correct option. Friend, there was a recent famous judgment in 2023 by Supreme Court, that is Manju Nath versus State of Karnataka, 2023. In this judgment, Supreme Court meticulously discussed Section 32. So anybody interested in uh, dis basically going through all the aspect of Section 32 of Indian Evidence Act, not 32 as a whole, on the aspect of dying declaration. So this judgment would be more than enough. Next. Question number 20. The report of medical officer stating the injuries of the victim is option A, conclusive in nature, incorrect. Option B, relevant and admissible in evidence. So this is the correct option. Option C is also incorrect. Option D is also incorrect. It cannot, since it is an opinion evidence, it is not substantive piece of evidence. Question number 21. Under which of the following conditions a leading question may be asked during examination in chief with the permission of court? So generally the rule is leading question cannot be asked in examination in chief, but in certain circumstances it can be asked. Option A, in the matters which are disputed or not introductory. So it is incorrect. It can be asked when the matters are undisputed or introductory. Option B, when the matter in question is sufficiently proved. In this case, question can be asked under both of the above condition, under none of the above condition. So option B would be the correct option. Question number 22, statement A. The presumption under 113A of Indian Evidence Act is not attracted if marriage took place more than 7 years prior to the suicide of the woman, even if cruelty is established by prosecution. Statement B. By introduction of Section 113 of the Evidence Act, the prosecution is not required to prove the facts beyond reasonable doubt against the accused. So, statement B is straightforwardly incorrect. स्टेटमेंट ए से इज दैट अगर जो 7 साल से ज्यादा हो जाते हैं शादी को, एंड इवन देन देर इज अ केस ऑफ क्रूअलिटी, सेक्शन 113A वुड नॉट बी एप्लीकेबल. सो ऑफ कोर्स जो 113A का जो प्रिजम्पशन है, इट रिक्वायर्स टू इंग्रेडिएंट्स. फर्स्ट इज लेस देन लेस देन 7 years of marriage, and second is the that has been in relation to cruelty. uh, So, hence the statement A is the correct statement. And with respect to statement B, in Savaldas versus State of Bihar, it has been held by the Supreme Court. Neither Section 103 or Section 106 absolve the prosecution from proving a case beyond reasonable doubt. Question number 23. During examination in chief of a case under Section 325 of IPC, the victim denies the prosecution's case. So in this case, the victim is denying the prosecution case. So under what provision of Evidence Act victim may be asked leading question? So this question is based on Section 154, which provides an opportunity to examine its own witnesses by the by whoever calls it. So it is a scenario when the victim is declared hostile by the person who calls it for examination. Question 24. Promissory estoppel is extension of principle which contained in which provision of Indian Evidence Act. So section 115 deal with promissory estoppel. Question 25. An information supplied by the accused under section 27 of Indian Evidence Act shall be recorded. Option A, in presence of two independent punch witness, incorrect. Option B, presence of gazetted officer, incorrect. Option 3 is also incorrect because it says two police officers. So none of the above option would be the correct option. Let's see the ingredients of section 27. It says, provided that when the fact is deposed to, as discovered in consequence of information received from a person accused of any offense in the custody of the police officer, so much of such information, whether it amounts to confession or not, as relates distinctly to the facts thereby discovered, may be proved. So we cannot see any of the options which are given above. So hence the option D is the correct option. Recently, Supreme Court highlighted 2 points that uh, uh, the person must need not to be in formal custody of the police officer for the purpose of section 27. So it would be within the ambit of section 27 even though the person is in the constructive custody or informal custody of the police when its arrest is not recorded in the police documents. Question 26. A woman subjected to rape gives a statement under section 164 implicating the accused for offense. She commits suicide later on, but before her statement could be recorded at the trial. Such statement recorded under 164 would be admissible. So it cannot be admissible as a substantive piece of evidence as stated in option A. Option B, admissible under section 32 of Indian Evidence Act. So this is the correct option. It cannot be admissible under section 33 of the Indian Evidence Act. uh, and although ये जो क्वेश्चन 26 का आंसर है वो देख ऑप्शंस में ऑप्शन डी दे रखा है बट एज पर माय considered opinion option B is the correct option and not D. I have found a recent case from Allahabad High Court. Uh, in this case, on para 27, the High Court stated that on perusal and consideration of the law above extracted, it becomes evident that the statement of a witness recorded under section 164 is not a substantive evidence. It can be used as corroborative. It can be used to corroborate statement of the witness. It can be used to contradict the witness. Such statement would either elevate it to the status of evidence under 32 of Indian Evidence Act if the maker of the statement subsequently dies or would remain within the realm if it of what it was originally. So if the witness dies, if the maker of the statement dies, it can surely be relevant under section 32. Question number 27. Two friends A and B were sleeping in a room which was bolted from inside. In the morning, A found murdered. Under which of the provision of Indian Evidence Act, prosecution can claim shifting of burden of proof to B to prove the manner in which the murder took place. So this question is based on the premise of section 106 of Indian Evidence Act which says that burden of proving a fact, especially within the knowledge of a particular person, he has to prove such fact. There was a famous case. There are in fact many famous case on this particular point, but I could remember case of Trimukh Trimukh Maruti Kirkan. Sorry, friends, for my bad handwriting. Trimukh Maruti Kirkan versus State of Maharashtra. TRA 2006 का केस है and in this case it was held that whenever a death occurs within the four walls of house, the prosecution cannot claim that all burden of proof is on prosecution, and they cannot keep silent by stating that since the burden of proof is on prosecution, they will keep quiet. So whenever any such thing like happen, and prima facie burden of proof has been proved by the prosecution, then it shift upon the uh, defense to state that to either explain the circumstances, or they would be covered under section 106 of Evidence Act if they fail to give a proper explanation uh, under what circumstances he parted with the company of the deceased. Next question. Question 28. In which judgment Honorable Supreme Court has laid down that a party who is desirous to proving electronic evidence but does not have access to the device from which document was produced is not required to produce and prove the certificate under section 65B of Evidence Act. So it says that uh, जिसको भी 65B का एविडेंस देना है, बट इट डज नॉट हैव एक्सेस टू द डिवाइस फ्रॉम विच सच इलेक्ट्रॉनिक एविडेंस इज डिराइव्ड फ्रॉम, लाइक जैसे अगर जो मेरे को एविडेंस देना है a photo which was captured from my mobile, but I do not have mobile at that time, so I need not to give statement. So in this was held in case of Shafi Muhammad versus State of Himachal Pradesh. In this case, the Supreme Court held that we clarify the legal position on the subject on admissibility of the electronic evidence, especially by the party who is not in the possession of the device from which the document was produced. Such party cannot be required to produce certificate under Section 65B 4 of Indian Evidence Act. Next question. Question 29. Indian Evidence Act 1872 applies to it basically applies to judicial proceedings before court only. So option C is the correct option. Question number 30. Special provision as to evidence relating to electronic record were inserted in the Indian Evidence Act. So it was option 1 is the correct option. 65B and 1710/2000 was the effective date. Question number 31. Which of the following facts are required to be proved? So this question is, I think, based on section 57 of the Indian Evidence Act, which says that facts which need not to be proved, or facts of which court must take judicial notice. So all the laws enforced, its judicial notice should be taken by the court. B also, the second option is also covered. Option 3 is also covered. So none of the option would be the correct option. Question number 32. Which provisions of Indian Evidence Act stipulates that the fact of women being habitual to sexual intercourse will not be relevant on the issue of consent in a prosecution for a rape or outraging the modesty of the woman? So section 53A is the correct option. Question 33. In which celebrated judgment did the Supreme Court classified the witnesses into three categories: wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable? So option 1 is the correct option. In this case, Supreme Court elaborated that there is no problem in in the cases of either wholly reliable witnesses or wholly unreliable witnesses, because if a witness is wholly reliable, then court may straight away rely on the such statement, and if he is wholly unreliable, then again the court would neglect the statement of the witness totally. But the problem arises only in the case of when the witness is neither wholly reliable nor wholly unreliable. In such cases, the court has to actively perform its task to separate grain from chaff. So this was held in this case. Question number 34. Which of the following statement is correct? Option A, I think this is a repeated question. We have already done, although option 1 is the correct option. Question 35. Which of the following provision of Indian Evidence Act permits the evidence recorded in one case to be considered relevant in another case? Section 33. It says that whenever he has the opportunity to cross-examine such person and he did not cross-examine, in such cases it could be relevant to in subsequent proceedings also. You may refer section 33 specifically for this matter. Question 36. Under which provision of law can a court direct any person to write any words, figures for comparison? So, section 73 of Indian Evidence Act gives power to court to direct the person present to write so that the court can compare the statement, handwriting or signatures. So it gives sweeping power to the court. Question 37. Which provision stipulates that lunatic can be competent witnesses? Section 118 itself says that lunatic are not incompetent unless by their lunacy they are unable to understand the question and give and able to give rational answers to the question. Number 38. Under which of the section it is provided that in all civil proceedings the husband or wife or any party to the suit shall be competent witnesses? Option 3 is the correct option. Section 122 says that either in civil proceedings or criminal proceeding, if it is between husband and wife, they can be they can be competent witness against each other. Question 39. Which of the following statement with reference to Indian Evidence Act is not correct? Option 1. Contents of document may be proved either by primary or secondary evidence. This is correct. 2. Primary evidence means the document itself produced for inspection. This is also correct. Counterparts of the document as against the parties who executes them comes under secondary. No, it comes under secondary evidence, counterpart when the counterparts of the document as against the person who did not execute them. So this is incorrect option. Options 3 is the correct option. Question 40. Section 87 of Indian Evidence Act provides that. So this is direct question. It is related to presumption of books, maps, and chart. Question 41. Which of the following statement with reference to section 3 of Indian evidence is not correct? Map or plan is a document. And this is correct. Option 2 is also correct. Option 3 is incorrect because a caricature is also a document, a cartoon type. Question number 43. A is tried for the murder of B by intentionally shooting him dead. In the trial, the irrelevant fact is, so we have to see irrelevant fact. Option 1. A was in the habit of shooting at people with the intent to murder. So this is irrelevant because this shows general tendency. Option 2. A on the other occasion shot at B. So this is specifically relates to B. This would be the relevant. Option 2 is the correct option. So, friends, these were all the questions which were asked from the Indian Evidence Act. And thank you so much for watching. I know these video are a little longer, but I have covered all the questions right from 2013 to 2021. So, if you like my work, so then please watch it completely. It would be for your own benefit and for reading accordingly with from the act. And thank you so much.